Hi, everybody. How are you? This is J.R. Richards. What's up with us? This is the California Lawyers Association Real Property Law section. What's up with us session for February 18th, 2021, hosted by me, Lee Peterson, to my lower than me, as far as I can tell. Furrow is also here, and we have a special guest joining us, Anna Liu. I did it. We got a Franz and an Anna. We got to remember how to do the correct emphasis on the syllable. Anyway, for our agenda today, this is what we have online. We have basically what I just did, the introduction. We have the interview with Anna, who's going to be talking about SB 91, some bullet points with that, and answer a few of our questions that we're posing to her. It's a pretty vast subject matter. We have here for her for a bit of time. She's going to give a full CLE on that next month. So just to let you know. Hot topics, new cases that Ashley is going to be introducing here, takings issues, easements over tribal land. And how do you pronounce that, Ash?
The Guelph Treasure.
Guelph Treasure. That's the interesting. I like that one. That's a really interesting one. I'm going to talk a little bit about my wellness month last month. I had an article in the E-News about that, and we'll talk a little bit about wellness. Upcoming CLEs. This is actually not referenced later on, but we have a couple in March. Private harassing speech, hate speech, epithets. I don't know who's giving that. And then avoiding legal pitfalls with real estate purchases and sales.
That's what I'm actually speaking on that seminar, JR. That's mine.
Which one, the harassing speech?
No, the legal pitfalls in residential purchases and sales. I'm speaking on a panel with Elva Harding and Jose Mendoza and Renat. So I'm very excited for that. We're gonna talk about it from both the transactional side of things, and then they will be talking about it from the litigation side of things. So
I love that.
Avoid issues in residential sales.
Yeah, I'm sorry. I love that topic. You know, one of the things that we have Neil Kalin, who's like writes all those forums for CAR, but I mean the subject matter of breach of contract and the purchase agreement and the pitfalls of that, really highly relevant these days. So thank you for doing that. Our next, we're doing this every month, third Thursday of the month. And so you're welcome to join us here. This is a free seminar, so or a free, what is this? This is a webinar.
Podcast, something.
What happened to Franz? Oh, there he is. This is our all-star cast. We have Neil, who's not with us today, but there's Franz. You look like you're about 18 in that picture. And then Ash, nice photo, Franz. And next, I thought we were doing, I'm sorry. Okay, let's move ahead and let's just introduce Anna at this point. We'll come back to Ash. Is that okay, Ashley?
Sounds good. Yeah, she's the star of the show today, so by all means.
Yeah, Anna is the star of the show. SB 91 is it's a hot topic right now, and luckily enough, on our own executive committee here at the CLA RPLS, we have Anna, who specializes not only in real estate litigation, but her firm generally does all kinds of evictions in one of the toughest venues to do it, San Francisco Bay Area. So we're lucky to have her here today. She's a partner at Stephen Adair McDonald and Associates, as you can see from her screen. She'll be with, and she's also highly active in the San Francisco bar and of course with us. So here's Anna. Turn it over.
Thanks, JR. Thanks for that warm welcome. And I'm really happy to be here chatting with you guys today. And we can dive into SB 91. Like we said earlier, it's not going to be a full in-depth presentation. We'll hit some of the highlights, the hot topics. We're not going to do a deep dive. We'll save that for later in March when we do a full webinar on it. But we'll hit some of the main points today and answer some pressing questions.
Great. So,
awesome.
Franz, you want to take it from here?
Yeah, I guess so. Well, Anna, thank you so much for being with us, first of all. And so I guess the very first really simple and basic question is what exactly is SB 91 and why should real property lawyers care about it?
Yes, absolutely. So Senate Bill 91 was signed by Governor Newsom on January 29th. So just went into effect last month, went into effect immediately. And basically what it does is there are some pretty key components. I'd say the first thing is it provides substantial eviction protections for non-payment of rent for tenants who haven't paid, and enacted some new procedural requirements. It extended just cause protections to all residential tenants until June 30th, 2021, this summer. And so I can get into a little bit more about what just cause means for those of our attendees who may not practice in rent controlled jurisdictions, or if you own property in those jurisdictions, what just cause means. SB 91 also limits local eviction moratoriums, and it does interact with both federal eviction moratoriums like the CARES Act and the CDC, Center for Disease Control's eviction moratorium. So there's a lot of interaction on both the federal and local level. It also, one of the main things SB 91 has done is it extends an older law that expired called AB 3088, which provided these protections for tenants. So that expired on February 1st, and then SB 91 extends that. Another really key thing that SB 91 has done is that it requires a new informational notice that landlords must give tenants who missed rent payments between March of last year and February 1st of this year. And that informational notice, we call it a CITRA notice. That notice needs to be served by February 28th. So that's another protection. And then this law also created some other new additional protections and delayed certain lawsuits, like actions to recover rent debt. So it's done a lot of things. Those are kind of the 5 key highlights that SB 91 has done. And then also, finally, it provides rent relief options for landlords and tenants. So there's some federal money that's been allocated to the state to distribute to landlords who haven't received rent money from their tenants.
Thank you so much for giving us that really quick and down and dirty synopsis of SB 91. So I guess one of my, just like a practical question, how are landlords responding to this? Are they freaking out? Are they okay with it? Like, is it something that is navigable, or is there just a lot of uncertainty around it?
Landlords, I think, aren't all fully aware of it. They are becoming aware of it through the news or the media, or bar associations that are putting out materials. So I think once landlords are becoming aware of it, the reaction that I've been seeing from clients is, oh my God, wait, what is this? And what do I have to do? And what did you say I have to do by February 28th? And if I miss that, what do I do? So there's a lot of confusion. There's a lot of uncertainty, but it's something that we're trying to put out more awareness and give more information for, so landlords can comply. I think, freaking out is probably a good way to describe some of the reactions we've been getting.
Yeah, that's awesome. And so what do you think what can landlords do now? I mean, so this sounds like, it's COVID and everybody wants to protect tenants and make sure that people aren't homeless, which certainly is okay. But what can landlords do? Because landlords have mortgages, landlords have bills to pay, and some landlords are relying on this. And also, are there any exceptions?
Yes, there are. So I'd say 2 big points are the SB 91 protections are in effect through June 30th of 2021. We've heard some chatter in the industry that it may be further extended, possibly through the end of 2021, but right now the protections are in effect through June 30th. And nothing in this law relieves a tenant's liability for unpaid rent. So this law isn't waiving rent or anything like that. It's just creating additional procedural requirements that landlords must follow before trying to seek rent or evict tenants for not paying rent. And also, like I said earlier, delays landlords' abilities to file civil or small claims actions for just the debt portion. There are some exceptions. This only applies to residential tenancies. It does not apply to commercial tenancies. It does not apply to transient occupancy like hotels, motels, and it doesn't apply to corporate rentals where the tenant is a non-natural person. So there are some exceptions, but broadly speaking, SB 91 applies to all residential tenancies in California.
And so, and it also is just a law related to non-payment of rent. So I guess on a procedural technical level, if a landlord wants to evict his or her tenant for, being a nuisance or, I don't know, doing drugs in the apartment or running a brothel out of it or any of the other legal things that people can do that violate their residential leases, they can technically evict them, right?
So great question. One portion of SB 91 extended another state law that was passed in 2019 called AB 1482. And AB 1482 created statewide both rent control and eviction control protections for tenants with certain exceptions. So the way SB 91 interacts with AB 1482 is that it extended just cause for residential tenancies in California throughout June 30th. So landlords must have just cause to evict tenants through June 30th. And AB 1482 has very specific just cause reasons. They break it up, the law breaks it up into fault-based, no fault-based, and there are some exceptions. We did a webinar on AB 1482 last year, which I think is still available. Folks can go back and check it out. But I'd say for purposes of this discussion, SB 91 just extended just cause protections under AB 1482 through the summer. And I will put one caveat on that is some local jurisdictions are prohibiting evictions unless they're for certain reasons. So just to give a quick example, like here in San Francisco, landlords are prohibited from evicting tenants unless the eviction is related to a health or safety reason or violence. And then non-payment of rent is permitted, but subject to SB 91. So I'm throwing out a lot of AB 1482, SB 91, but it is pretty dense. And like I said, we'll get into this in a later webinar. We wanted to kind of hit all the highlights today. But yes, to more directly answer your question, SB 91 did enact just cause protections for tenants through June 30th.
Can I jump in and ask
Right.
Franz?
Oh yeah, sure.
So if Anna, so if that extended AB 1482, so if a property is exempt under AB 1482 rent control, then those just cause restrictions wouldn't necessarily apply, right? You could terminate for other reasons.
Yeah, so it's a really good question, Ash. Actually, so I should back up and say AB 1482 applies to California too. So there's rent control and eviction control, just focusing on the eviction control portion. It applies to most residential properties that are older than the past 15 years. So it's a 15-year rolling window. But actually now, because of SB 91, that kind of 15-year doesn't matter anymore. It's going to apply to all properties. But there are some exceptions, like for single family homes and condos that aren't owned by corporate entities, real estate investment trusts. So yeah, one thing people aren't always aware of is even if your property is exempt from AB 1482, let's say because it was built last year in 2020, at least through June 30th, those just cause for eviction protections are going to apply to the property. So an owner will need just cause if they want to terminate a tenancy, at least through June 30th.
Okay. Thank you so much for that. And I'm seeing a lot of questions in the chat. Some of them seem very fact specific. So I will try to make them.
I got a quick one out of the chat. I thought it was kind of interesting. So if an owner forecloses on a property and the former owner is the tenant or is now still in possession, SB 91 doesn't affect that kind of situation where there's a foreclosure and the former owner is getting dispossessed, correct?
Yeah, that's a little bit of a different scenario. There's a statute for specific holdover owners or former owners who are holding over after a foreclosure. So that's a little a specific situation, a little more fact-based that we can get into. But there's a different statute that applies.
Yeah, that's all the question was. Thank you.
Yeah. I was going to say, I see a lot of very fact-specific questions in the chat, so I'm going to try to make them a little bit more general. But so one person asked, can eviction be done for reasons other than non-payment of rent? And I think my one really practical question here is, whether evictions can be done or not done under this statute, what is really happening with evictions when people are trying to be evicted? Like, is the existence of these sort of protections, is it making it harder to evict tenants, even if there is a real reason to evict the tenant?
It is. And to answer that question, it's really city specific and county specific. So I would say you have to look at your city, what city you're in. If you're in, Los Angeles may have specific restrictions. And then you have to look at the county. Counties also have very specific restrictions. And then statewide, we've got SB 91. And then at the federal level, there's the CARES Act and the CDC. So it's kind of hard to just give you can't give a blanket answer to that question. You've got to really look at your specific city. For example, like if you're in Contra Costa County in Northern California, there's specific restrictions as well. So to kind of more answer that, we got to dive deep into each level of government to see what's prohibited or not.
Right.
I got a quick question for you, Anna. Have you found that a lot of people are falling back on either owner move-ins or Ellis Act evictions because they just got to get rid of the property if they're not getting paid?
Yeah, totally. One thing that's really interesting, I'll say for San Francisco, that's where my office is located. We see a lot of owner move-in evictions, but right now we can't go forward with them because they don't fall under one of the exceptions to the current San Francisco eviction moratorium. And what's really unique is in San Francisco, we have what's called a school year ban. So you can't serve an owner move-in eviction that expires during the school year. And so because of the way the laws are getting extended, a lot of owners are, kind of out of luck because it's very likely that these moratoriums will be extended throughout the summer. And so owners may not be able to get that in time. So we are seeing a lot more clients who are calling us saying, you know what, I just want to get out of the rental market, take my off, serve an Ellis Act notice. Yeah. So we're seeing a rise in questions related to that. There are a lot of, again, like I was just saying, really city specific restrictions. Ellis Acts can go forward depending on the city you're in, like Oakland, that's an exception.
Yeah.
So what I'm really hearing is that, lawyers are now going to be able to bill their clients for doing all of the necessary research to figure out what really applies and how do all of these different statutes and regulations and orders all fit together to, cause a specific scheme for their clients. And so really, I guess it's just up to lawyers to do that research and figure out how their clients are impacted.
I agree with you. And, for the property owners out there, or even the tenants out there, there's a lot of uncertainty. So I would say if you've got a question, call a lawyer because it's a little difficult to figure out. There's a lot of good organizations out there that put out materials and put out information, and the state has put out information as well. So as our organization, the CLA, we're doing webinars and keeping up to date on all of this. I'd say biggest thing is contact a lawyer. Yeah, JR.
So I wanted to add is just the other day, I'm not sure what date it was, but Michael Simpkin, who's also in our group, just did a webinar on navigating the current landlord-tenant situation. So anybody here, we have Anna coming back next month to give a full-on CLE on it. We had Michael Simpkin the other day, who just fantastic. So if you want to look that up, all of our stuff all of our CLEs are in a library that you can get. So just thought I'd mention.
And Michael's here.
Yes.
Oh, hey, Michael.
Yes. Hi, Michael. And also thank you for that. So we're kind of coming close to time because we're looking at, about half an hour. So I think one of the real questions that I had is sort of in your experience in what you do, moving forward, what do you kind of see sort of practically happening, right? I hear that you're saying, okay, it doesn't absolve people from the responsibility of paying rent and they still have to pay rent, but it's like, what is this really practically going to do? Because if you owe, I don't know, $50,000 in rent, which is not unreasonable for a place like San Francisco, if you haven't paid rent since COVID started, right? Like, are these people really going to be able to pay rent? How is it going to affect their ability to get housing in the future once these are lifted? And do you think that there's any sort of statutory or policy decisions that are coming down the pipe that are going to address some of these issues?
Yeah, I'll say that in my opinion, these laws, AB 3088, SB 91, they were put together pretty hastily in an effort to create protections for tenants. So I don't think that, I think there's a lot of kind of gray area, and we'll see how courts are going to interpret and litigate a lot of the issues that are going to come up. You did touch on a point I wanted to mention, Franz, which is tenant screening. And you had mentioned, are tenants going to be able to get new housing if they've, got this blip, let's say, on their record? The civil code was amended. I think it's section 1785 that talks about landlords can't use COVID-19 rental debt as a negative factor in tenant screening. So the legislature did think of that aspect, but landlords understandably are going to want to know, hey, is this tenant I'm bringing into my unit, do they have rental debt that I want to know about? So the civil code was amended to add in that tenant screening prohibition. Someone asked a good question earlier about late fees and like security deposits. And I thought I would just quickly mention, because I think that's a really good question that I get a lot of calls to my office. And the CCP was amended. So for security deposit, you cannot use that during the tenancy unless the tenant consents. That was, I think, amendment to CCP 1179.05, somewhere in there. And then late fees as well. If the tenant submits a required declaration, that we didn't quite get into the nuance of that, but when tenants submit a required declaration, you can't ask for late fees, and that's also in that CCP amendment. So I get a lot of those questions. I just wanted to throw that out there.
Yeah, there were a lot of questions too about the rental assistance program and what that means for landlords and tenants and how. So I know the burden is now on the landlords to apply for that, but what's the situation?
Yeah, great question. Just to spend a couple of minutes on it, really broad strokes overviews. There is going to be assistance for tenants who haven't been able to pay their rent. It's federal money being distributed through California. To kind of give you a breakdown of it, landlords can elect to accept 80% of unpaid rent from a specific period. It has to be rental debt that was owed from April 1st of last year through March 31st of this year. And if the landlord accepts the 80%, they must forgive the remaining 20%. But tenants have to be eligible. So the tenant household has to be at or below 80% of the area median income, the AMI. The state is giving a priority based on 3 different groups, like helping households below 50% of the AMI, they get first priority. And the application period for this federal money is opening up on March 15th, 2021, so next month. And presumably the state will have the process and everything up and running before March 15th so that landlords and tenants can apply. There's a whole lot to talk about the rental assistance portion. I'll say my kind of opinion, broad strokes over it is we're going to see how that money gets distributed. Like I said, round 1, it's going to go to households who make less than 50% of the AMI. I think round 2, it's communities disproportionately impacted by COVID. And then round 3 is all other remaining eligible households. So we'll see how quickly that money goes and which groups it's going to, because the state has allocated different blocks.
So it's just clear as day how this is all going to work out, huh?
Yes.
Anna,
Neil, thanks.
Anna, just thank you so much. I mean, we made obviously a whole hour or two, and we really thank you for your time. Your specialization is really valued, and your advice to all of us is really valued. So thank you again, Anna. And
Yeah, you're so welcome. Thanks for having me. I just wanted to point out to everyone, Neil, thank you, Neil, threw out in the chat a website, housingiskey.com, that's put out by the state. Go to that website. There's a lot of good material and information on there as well.
awesome.
Uh,
Any closings, Franz?
Well, you definitely kind of closed it out for me, so thank you. But thank you very much, Anna, for being with us. I really did. Hold on. Oh yeah, Michael. Actually, Michael made a really helpful comment, so I'm just going to read that, which is the practical issue for landlords is wanting to file evictions other than for rent. Then CCP 1179 and part of SB 91 applies, and that says that you can look at all grounds under CCP 1946.2. Yeah, so it seems like there's a practical consideration of just like trying to find ways of evicting people, as opposed to, you know, if they don't pay rent, then what are some other ways of getting rid of this problematic tenant? But it really seems like, at least from what I've seen and heard, it seems like courts are just a little bit more leery about allowing evictions no matter what, under any circumstances. And so it really just puts landlords in a really difficult position because, you know, they're not renting out their properties because they're charitable. They're usually renting them out because they either want money or they need money. So, you know, I'm really curious to see how this all shakes out in the future.
We're sorry if we couldn't get to everyone's questions today. Again, this is not a deep dive into Senate Bill 91. So please keep if you have questions that weren't answered, you can email Anna separately or on-off separately, or you can attend her webinar, even better, next month, which will have a lot more information for you.
Great. Thank you so much.
Awesome.
You're welcome to stick on and if you like, but again, we understand your time's valuable. So if you want to move on, you can. We're going to go back to Ash on our hot topics. Let me see if I can navigate that. I'm obviously really good at this stuff. Here we go.
Can you go back? There you go. Got it. Okay.
Am I there?
Yep, you're good.
So,
okay, so I'll try to keep this
over to Ash.
brief. Yeah, I'll keep it brief today. I know we wanted to focus more on Anna's interview because that was more relevant. So just a couple of updates on some takings lawsuits that are happening right now with regards to COVID. So this Bowles v. Newsom case is in the U.S. District Court for the Southern District. It's actually based out of San Diego. So it's a San Diego plaintiffs who brought this suit. The plaintiffs include a landlord who owns a commercial property in San Diego, and then his tenants who are hair and nail salon owners. So they filed suit against Governor Newsom, the Attorney General, the public health officer, the mayor of San Diego, and the San Diego Board of Supervisors. So they threw the whole kitchen sink in there after they're suing. The defendants filed a 12B6 motion, which that takes me back to civil procedure in law school. I don't know about you, JR.
Absolutely, 12B6.
So the defendants filed this motion to dismiss on the absence of sufficient facts and lack of a cognizable legal theory. So the plaintiff's claims included several causes of action, but I'm just focusing today on the takings clause arguments under the Fifth Amendment. So the plaintiffs argued that the COVID shutdowns and the eviction moratoriums have resulted in an unconstitutional deprivation of all economically beneficial use of the income property. And the moratoriums are basically preventing him from being able to re-rent the properties. So the hair salons also filed a takings claim, claiming that the shutdowns have taken away their occupations and their businesses for the public good without compensation. So obviously the defendants fought back on that, and the courts actually found that there was sufficient facts asserted to meet the Federal Rule of Civil Procedure 8 standard of a short claim statement of the claim and plausibility. So they were allowed to move forward with their case, and the motions to dismiss were denied. JR?
So I think it's really interesting, the issues that Governor Cuomo is facing and Governor Newsom. So obviously they were using their emergency powers to do a lot of these things during COVID. But obviously I mean, it seems to me that there's a big kind of pushback from businesses, small businesses or other businesses against the use of that. Again, claiming it was unconstitutional and an invasion of their rights. Do you think that these lawsuits are going to last for another 10 years?
Well, I don't know, because I mean, if the moratoriums lift, then does that render these cases moot? You know, it probably does. So I don't know. I mean, I think there's obviously a rush to getting these filed and heard right away because of that alone. So I don't do litigation, so I'm probably not the person to ask, but I do think that that's probably a one factor to consider here.
Cool.
And I think it's interesting that they're coming up with these other causes of action that are a little bit unique, but might also work. You know, I mean, the takings clauses are interesting, and I'm sure that they're going to be pending in a lot of commercial cases as well. So, so similarly, there's these other sister cases that were filed as well. One of them was filed in Superior Court, and then they filed a sister case in federal court. So that's why there's two listed there with the same name. The state court case was from the county trying to file a TRO to prevent a gym owner from, operating in violation of the county health orders.
Yeah.
And the federal case was an asserted inverse condemnation claim under the takings clauses. So it's really interesting that these are still pending right now. We don't know how these are going to get decided. So it'll be interesting to watch these cases. The plaintiffs tried to remove the state court case to federal court and have it heard in federal court, probably because of what's going on with that other Bowles case. But unfortunately, the federal court did not agree to the removal on this one. So there's still both cases are pending. So we'll see what happens.
I was also going to say that I think that there's an interesting interaction between all of this COVID stuff, and there was a rent control law passed in New York City that was being challenged by by property owners in New York City under the takings clause. So it'll be kind of interesting to see how, the takings clause takes shape under these sort of like federal or governmental restrictions on property use as compared to, actual taking.
And Michael asked an interesting question. He said, will a case like Bowles hurt or help a tenant with business interruption insurance? That's a good question. I know that most cases with the business interruption insurance have not been permitted to go forward. So I think that this may be their only other remedy at this point, possibly. But I don't know that for sure. So.
Well, I mean, it is interesting. So who's going to bear the brunt of the costs of like businesses shutting down and not being able to operate? Like my town itself, like 50% of the commercial properties have for lease signs out front of them. It's incredible. I mean, who's going to bear the brunt of that? What kind of insurance is going to pay for that? Eventually, they have to work out the policy decisions on that.
Right. And I mean,
clearly.
We talked about those cases on one of our other WhatsApps, and it was that most of those cases were getting dismissed that were filed against the insurance companies for the business insurance. So I think that's the struggle right now, but we'll see what happens with that.
What's going on with this the tribal land public easement issue? Yeah,
so this one was just kind of interesting. I just pulled that in there as a side one, but basically it was filed in January of this year. The plaintiff is a kayak rental business owner, and he brought a quiet title action to try to establish a public easement for coastal access over tribal lands. And he was basing his argument on the allegation that the prior owner of this property, before it was sold to the tribal lands, had dedicated a portion of it for public use. So he tried to argue there was a prior easement there, and that he also claimed that the tribe might interfere with the coastal access in the future. So it was more of a preliminary preventative measure rather than a claim where there's something that had already happened. So the court didn't really like that argument, mainly because tribal immunity is really only subject to two exceptions. One is when the tribe has waived their immunity, which didn't happen here, or when Congress has authorized the suit. So neither of those happened. So the court basically was kind of like, this is an open and shut case. There's no grounds to be able to go after the tribal lands because they have immunity. So the motion to quash was granted, and the case was dismissed with prejudice. So that was a pretty hard slap on the plaintiff's side.
It It's interesting, the public lands issue, the public easement, public dedication laws are pretty interesting. A lot of times you have to look before 1972 as to whether there was a public dedication or not.
Yeah.
And so that was part of the argument they were making. How about Guelph? Tell me about Guelph.
Yeah, so this was one I talked about a couple months back. I can't remember if it was November, probably November when we talked about this last, because I thought this was a very interesting case. And I know this isn't real estate related, but it was one that we had previously discussed. So I thought I'd follow up on it since it was a Supreme Court decision. But for those who weren't on that call last time, the Guelph treasure was basically medieval artifacts that were gold and silver artifacts that were sold from the Jews to the Nazis in World War II for far less than their actual value. So the heirs of the Guelph treasure have sued in the United States courts to try to get that treasure reclaimed as being spoils of war during genocide time periods. So I was an art history major, so these art cases are super fascinating to me. But there were multiple, it went to the district courts, it went through appellate courts, and then it went all the way up to the Supreme Court, which had just rendered their decision on February 3rd. And Justice Roberts gave the decision of the court. It was actually a unanimous court decision, which you don't see that very often. But basically, the question was whether the sovereign country can, essentially be sued for property takings in the United States. So basically, the court said, no, we're not going to go as far as to let you be able to do that. We don't want the United States to rule the world in our court cases, and we would have, there's other grounds and remedies for these plaintiffs to pursue their claims in courts in Germany and so forth. So unfortunately, the heirs didn't show sufficient grounds for them to be able to bring their claims against Germany and the United States. So if you want to look at the Supreme Court decision, there's a link there. And it looks like Franz included a link to what the Guelph treasure looks like and what it is with a WikiLeaks. So that's my hot topics for the day. I'll try to keep it short and sweet.
Awesome, Ash. As always, way cool. That Guelph treasure just fascinates me. It really does. Like, there's no doubt that it was essentially stolen from them. But really, what is their remedy at this point to kind of get that stuff back? I mean,
right. Well, and there's like mediation things that they had to go through. They would have to go through in Germany or Austria or whatever. So there's other remedies, and those didn't work for them. So that's why they went this route, and that's why the courts were kind of like, we're not going to set a new precedent here, because that would open. They were saying it would open up a whole nother. Basically, it would open a can of worms, because then you could start bringing human rights violations claims and all these other things that really are meant to stay within the country and where those happened. So fascinating stuff.
Yeah. Well, I was hoping to talk a little bit about both Ashley, actually all three of us, Franz, Ashley, and myself are all part of the Wellness Committee for Real Property. It's been a real pleasure working with them. And so I wanted to share a little bit about my January. January is kind of critical because a lot of people have New Year's Eve resolutions. CLA had a wellness challenge. And then in the real property section, we got some really cool stuff kind of going there. So I wanted to share a few fascinating conclusions about kind of how my month went. One is they had a challenge to avoid social media for a day. And I just did it. It's actually kind of hard because was so in the habit. And then it was weird after the day was done. I haven't been on social media since that day. And it's not because I'm like a hater or don't like it, but it's just been nice to avoid it. Very freeing, actually. I mean, Ash and Franz, do you have any social media policies personal?
Yeah, I deleted Facebook back in October. So I'm actually very happy with that decision. I still have Instagram, but that's only for private use and not for any of the crazy work-related stuff anymore. So I do miss being able to advertise events for things that I would promote, but other than that, I don't miss it at all.
Oh, so I have a thing on my website. When I post on my website, like a blog, it propagates to my social media. So I communicate to social media, but I don't actually go there to see the result. So,
Nice.
thank you.
I mean, I have moved away from social media as being social, and it's more of just an advertising platform. And when I actually just think of it as like a purely advertising platform, it's extremely effective at that. And I don't really engage in sort of like social media as a way of socializing with people.
Cool. Well, so the other thing that happened to me is they had a gluten-free day challenge. And like I'm the kind of guy, honestly, I didn't know what gluten was. I'm just not there. I'm not there. Okay. So I'm in California. You can, kill me if you want to. But so I actually had to consult with my wife about what exactly is gluten-free and what is, I don't even know. And so it was interesting. I don't eat a lot of breads in my diet, but I substituted sweet potato, like kind of chips instead of bread in my breakfast. So I kind of use like this George Foreman grill to roast them up, and I love it. I've hardly had any bread since this time. It was like kind of a cool dietary change. I don't have a problem with gluten, but it was interesting to go gluten free, and I kind of like it. I don't avoid it, but I kind of like being gluten free. Either of you have any dietary changes or things that you do?
Yeah, I mean, when I was diagnosed last year with Crohn's disease, I had to completely change some of the stuff that I was eating. So I've really limited dairy now, and I really limit gluten. So that's and now alcohol, unfortunately. So yeah, I feel your struggles.
So does that alleviate or lessen the impact of Crohn's on you to avoid those things? Is that what happened?
Yeah, it does. It definitely does.
Okay.
Yeah.
Okay. Franz?
I'm trying to think. I mean, I tend to not eat out much. So I think I mean, I like to cook anyway, but as a result of the pandemic, I've just kind of like, I'm not out. So I don't like saying, let me stop at this restaurant and get food. So I will
Right.
cook more often at home, which I think has been my pandemic, a sort of pandemic related dietary change.
Yeah.
And I really have enjoyed just cooking for myself or cooking for us and not like eating out as much.
Yeah.
I do love my pasta though, JR. So I haven't really given that up completely.
Last night I had full blown regular pasta. It wasn't even wheat or whole grain pasta. So
The
I love
gluten-free
it.
pastas
Really
just don't,
tasty.
they just don't taste the same. It's just not as good.
So, I always think it's fascinating. People are saying, well, because of COVID, I'm eating a lot more ice cream and stuff like that. I actually find it more like along the lines of what Franz is saying, because I'm not going out. I can be a little more disciplined to what I'm eating and kind of a little more picky. So,
Yeah.
so the other thing I did is I was going dry in January, and I'm trying to lose a little weight, and alcohol is a lot of extra calories I don't need. So I've gone continue to be dry. I'm still dry. So it's about a month and a half here.
Have you noticed weight loss, JR?
Well, so I mean, like I'm tracking my calories and trying to eat a caloric deficit. I've lost about 6 pounds.
That's good. That's great.
Yeah.
I'm not trying to lose it too fast, but it's still it's good to lose some pounds. Have either of you ever done a walk and talk?
No.
So
I don't actually know what that is.
Yeah, so I set up a meeting with a friend I hadn't talked to in a while. This is part of the CLA challenge. And we took an hour. I took a walk in my neighborhood. He took a walk in his neighborhood, and we sat on our phones, and we were on our phones, and we talked to each other like we were walking with each other the whole time. But then it's a walk and talk. You don't have to actually be together, socially distanced, and it was super fun. It was better than a Zoom meeting.
I have definitely walked and talked to people, but I don't know if they've been walking and talking to me at the same time.
That's the point is you're both walking at the same time. You're walking through your respective neighborhood. Anyway, it's super fun. I recommend everybody try it. Otherwise, just to touch on a few other things, we're going to wrap it up here, but we had Ritu Goswami come and give a speech on how to be more efficient. Ash and I got paired up at one point. Franz, did you organize? No, who organized that? Ash, did you organize that?
I did.
Yeah, she organized both.
Franz, you were there, weren't you?
Yeah, I was there for the Kelly Quarter yoga
Okay.
thing, which was really awesome. I had a lot of fun. And my sister-in-law was looking for something to do, so I think I kind of roped her into doing that as well.
Yeah.
So that was fun. And I was not able to go to the Ritu Goswami boundaries conversation, but I definitely, it's really, boundaries are really important. And I definitely reached out to people and was like, you have issues with boundaries, so maybe you should go to this. More like you have told me that you have issues with boundaries, so you should go to this.
Well, thankfully, Ashley organized both of those. They were fantastic. If you don't know, Kelly Quarter is a yogi, right? I'm not really good at this terminology, but she's going to likely be doing a class for us once a month, right, Ash?
Yeah, that's the hope. I think we're going to try to get that set up. So if you missed the first one, definitely participate in our future ones because she's awesome, and definitely it's all levels are welcome.
Yeah, like me, totally beginner. I stink at yoga. It was perfect for me, but obviously if you're more advanced, it would have been fine.
Yeah, it was a lot of fun.
And then Ritu was great. I think I learned more about putting boundaries up with clients more than anything. How about you, Ash?
Yep. It's funny now, I hear her voice in my head when I answer the phone for a client. She always tells us that we need to like set the parameters of the call up front. And I'm always like, wait, how do I even do that? I don't know. So
More assertiveness. I love it. It's awesome.
yeah.
Any other comments on that stuff? Oh, that's a picture of me taking the yoga class. That's Kelly Quarter teaching the class. And then I was in my office. I left my house so I didn't embarrass myself in front of my family. So I could.
I love that you got a picture of that. That's so great.
And then what's up with us next month? We're going to be back better than ever. Find a new interviewee, some more new hot topics, things like that. Any last regards? Oh, be there or be Neil Kalin. I used to say square. Shout out to Neil. We miss you, buddy. Any last comments, folks?
I think that's it.
All right, group. Well, thank you so much for joining us. I know it was really Anna's really important subject matter, and everybody had a lot of questions. And I don't know if we're ever going to answer all the questions, but she'll be back next month. Michael Simkin, who is also here, is a great reference as well. So thank you all. Thank you, Franz. Thank you, Ash. Thank you, Anna.
Thank you.
Thank you all. Thanks,
Sarah.
Anna.
Cheerio.